This is Duke University.
Started in just a second, once the webcast is rolling. I'd just like to welcome everybody to the 42nd Annual Duke Law Journal Administrative Law Symposium. This year we're going to be focusing on emerging alternatives to the traditional model of rulemaking. I want to begin by welcoming a few people and thanking a few specific people. First of all, thanks to the events office for helping coordinate all the logistics today and helping us with our dinner last night. Second, thanks to Christy Compost, the journal coordinator, and Jeremy Mullum, who also works with the journals. To Stuart Benjamin, who helped me brainstorm ideas for this symposium and helped us come up with the plan to have a call for papers and prospectuses this year. Also to Justin Becker in particular and the rest of the Duke Bar Association for helping us with the funding for this event. To Jonathan Wiener for helping moderate this panel this morning, and to the other moderators as well. Thank you for donating your time, preparing for the event, and spending time here today. Thank you to the members of the Duke Law Journal, particularly those who helped select from the many prospectuses we received and who have helped edit these pieces and get them ready for publication. And finally, and most importantly, thank you so much to the participants in the event for traveling from all over the country to be here. We're really excited to engage with you and talk about these papers, and hope that you're excited to be here as well and to engage with one another. So thanks so much for being here. I want to talk very briefly about the process that led up to today, just because we're doing things a little bit differently this year. In the past, the way we work the symposium is simply to pick a topic and then to pick specific people and invite them to write a paper. This year, as editor-in-chief, I wanted to focus on really getting the most exciting and most well-written scholarship that we could. So we decided that the best strategy for getting those papers would be to put out a call for papers and ask all the top administrative law scholars from around the country to submit papers. We did that. We received around 80 proposals, which we were excited about. And then me and the rest of my article selection committee, which is 11 people, read all of the different prospectuses and selected what we thought were the 6 best, most well-written, most exciting pieces of scholarship. And those are the people we asked to be here today. Fortunately, I'm happy to tell you that our goal worked, and those prospectuses have turned into fantastic papers, and also happen to be written by a lot of the emerging and most exciting scholars in administrative law today. So that's just a little bit of background on how we ended up here. We luckily also chose prospectuses that kind of coalesced around a theme, and then we've split those themes, that larger theme, into 3 different panels today. The way the format for today will work is we're going to have 2 panels in the morning, a lunch in the middle, and then 1 panel this afternoon. Each of the panels will be led by a moderator who has a particular interest in that area. The panels will begin with the different participants summarizing their papers briefly for those of you in the room who have not already read them. And then the moderator will get us going with a little bit of question and answer session, and we'll, of course, open up the question and answer session to the rest of the room so that we can all engage in a broader conversation about this issue. So without further ado, we'll go ahead and get started. Thanks again for coming, and thanks again in particular to our participants.
As Sarah said, thank you guys for being here, and I'm here to introduce our first moderator, Professor Jonathan Wiener. Professor Weiner comes to us, obviously, from right here at Duke Law School. He is the William R. and Thomas L. Perkins Professor of Law at Duke Law. He is also a professor of environmental policy at the Nicholas School of the Environment and a professor of public policy at the Stanford School of Public Policy. He has taught courses in environmental law, climate change, property law, and risk regulation, just to name a few. In 2008, Professor Weiner was the first law professor to serve as president of the Society for Risk Analysis. Particularly relevant for today's discussion is that before coming to Duke, he worked on U.S. and environmental policy at the White House Council of Economic Advisors, at the White House Office of Science and Technology Policy, and at the U.S. Department of Justice. He served in both the first Bush and Clinton administrations. He helped negotiate the Framework Convention on Climate Change and attended the Rio Earth Summit in 1992. In 1993, he helped draft Executive Order 12866 on regulatory review. He has also written widely on United States, European, and international environmental law and risk regulation. His work has been published in many different journals, including the Yale Law Journal, Harvard Law Review, and Georgetown Law Review, just to name a few. Thank you again for being with us today, Professor Weiner.
Thank you so much. I wasn't expecting an introduction, but it's very nice to be here at home, as it were, and to introduce this session and to congratulate the students of the Duke Law Journal who've organized such an exciting and interesting symposium. Every year I look forward to the Administrative Law Symposium of the Duke Law Journal because it brings fascinating scholars and interesting topics to us. And some years there's a theme, and some years, as Sarah Boyce was saying, there is a call for papers to try to find the best available athlete scholars all around the world. So first I want to thank and with you congratulate the editors-in-chief of the Duke Law Journal, Sarah Boyce, and incoming editor-in-chief Katie Ertmer and Alex Costanza, who just introduced me, and all their team for organizing this event. And second, I want to say that, in a sense, as I see it, there is a theme for this year's Duke Law Journal, which is the complex intersection of politics and administrative law, which seems to run through all three of the panels. So I'm delighted to introduce our first panel today, which is titled The New Toolbox, a phrase I like because many of us have been writing about the regulatory toolbox and the tools or instruments available to regulators for many years, and trying to think creatively about both tools for regulators and tools for analysts, for scholars of regulation, to understand regulation is, I think, a very both pragmatic and very insightful way of approaching those problems. So in our session on the new toolbox, we have two speakers, and I'll introduce each as they're about to speak, Professor Tom McGarity and Professor Kathryn Watts. First speaking will be Professor Tom McGarity of the University of Texas Law School. He is one of the most eminent and well-known scholars in administrative law over the last 3 or 4 decades. He's been a prolific author of books and articles about administrative and environmental law, including topics on, such as preemption, bending science, how special interests corrupt public health research. My favorite of his books is Reinventing Rationality, the Role of Regulatory Analysis in the Federal Bureaucracy. And he's really written on an enormously wide array of topics. I sometimes think of his range stretching from bones to beef. That is, I'm thinking of his work on ossification, which is, of course, is bones, and mad cow disease. Loved your article on mad cow disease a few years ago. So Tom McGarity's title today is equally fleshy. It's Administrative Law as Blood Sport. So with that, let's welcome Tom McGarity.
Thank you, Jonathan. I guess in the first description of the group that's here as emerging scholars, I think that applies to everyone perhaps but me. I emerged many years ago, and I don't know whether for the better or the worse, but here I am because I did want to, when the email came about this writing a prospectus and a sort of competition for a spot here. Well, of course, that gets our competitive juices flowing, right? But more than that, I had this idea I've been germinating about. I had just completed a book that talked about the last 30 years worth of regulatory reform and tort reform, sort of blending them all together in a title that's, I'm sure will be provocative. It's called Freedom to Harm. And having thought about that and watched some of these kind of strategies evolve, I thought I would like to write a piece about just the strategies that, as I was following, that book got me into the financial regulation, which I was not an expert in and don't claim to be now, but had to become familiar with at least. And so I watched the Dodd-Frank as it evolved. I watched my friend and former colleague Elizabeth Warren as she endured the travails of being on the hot seat. and decided I really wanted to write an article about, I'm not saying this is for all administrative law, but for high-stakes rulemaking, high-stakes policymaking. I think it's probably generalizable to policymaking in general. We really have, I think, evolved into or are working on a new model here. I start from the foundation of erosion theory, that Congress acts in response to crises. Gradually over time, the beneficiaries come forward, the Congress solves the problem or thinks it does or tries to, and over time, the policies sort of gradually erode. And also from the I guess, perspective, the insights of the political science community who've been looking at this, McNoll Gast, my now former colleague Dan Rodriguez, who have looked at the role that non-lawyers, that other policy-making arenas might play in administrative decision-making. And having done that and looking at the Dodd-Frank and looking at fights, this actually was a much longer article at one point, and the editors quite rightly said, look, just use one example. But I had two examples, and the other is the fights at EPA as it decided to expand its work on clean air to include global warming. And so I included the power plant rules, which was the endangerment finding that EPA made, and various rules, the cross-state rule and an air toxics rule called the utility MACT rule. So that was all in the paper at one time. It's all out now, but I left enough of it so that I'm trying to convince you that this is not generalizable across all rulemaking, but generalizable to high-stakes rulemaking. So my thesis is that we may have entered a period where the nation is so deeply divided as to the proper role of government in society that political discourse has become so unconstrained that a more expansive model is necessary for these high-profile rules. And first, I think the implementation game, as Bardak called it, which is a great word for it, the implementation game is spread into arenas that are far more political than in the past, certainly more political than, and there always are exceptions in the past too. I don't want to make this as some kind of clean break. This is something that's evolved, so it's more this way now than it was, I think, when I started teaching back in the 1970s. Much more, I think. But more political than the hearing rooms and the appellate courtrooms of the past. Second, the cast of players has expanded from not just the agency, the regulated industry, the beneficiary groups, public interest groups, et cetera. And even I'm willing to include in the old model the Office of Information and Regulatory Affairs, which has certainly been incorporated into the decision-making process these days, in the Office of Management and Budget, or OIRA as we call it. The playing field has expanded beyond that. It's been there for some time to include organizations with broader policy agendas, not just the regulated industry, but the Chamber of Commerce, major player in all high-stakes rulemaking. Think tanks, grassroots organizations like the Citizens for Sound Economy, it used to be, and it morphed into something called Freedom Works, and it's become far more strategic, where you pick your battles where you think you can win, and where the battlefield can be shifts. And it's not just the agency, it's not just the rulemaking record, but it's at the White House, it's over at Congress, as a committee may be ramping up some hearings, or you can persuade the committee to ramp up some hearings, give it some questions to ask, get that administrator, while the decision's being made, while the comments are being filed before you, to try to make that decision maker commit as to the outcome of the decision-making process. And frankly, browbeating the decision makers sometimes if they're unwilling to do so. I have a little passage in there from one of the members of the Federal Reserve Board I use as an example, this interchange fee rule, which was just absolutely fascinating and kind of close to home. Everybody, not everybody, I don't, but most people use debit cards. My wife won't let me. So I don't use debit cards, but it's something that's near and dear to everybody's heart. And the amazing fights that happened over just this silly little debit card when lots and lots is at stake. And finally, we have this deeply divided political economy. I don't think anyone, this may be one might dismiss this paper as a sort of Tea Party phenomenon that'll go away, but I really don't think so. I think that this has been evolving. This has been happening ever since Ronald Reagan said the problem is government. And I think that we now have a really two very divided opinions about the role that government plays in society. So anyway, former SEC Chairman Arthur Levitt called it blood sport. And I think there's some truth to that. And so I took that metaphor as a sort of starting place. I go in the paper through various characteristics of blood sport rulemaking. As always, thoroughgoing participation, lots of submissions, lots of doing your own studies and submitting those to try to persuade the agency to see things your way. Vigorous lobbying of both the agency, they called them, back when I worked at the Environmental Protection Agency, I think they still do, the hall crawlers, the guys that are just there talking to the staff, and certainly the higher-ups that are meeting with the administrator. I think I left in the article the meeting with that Luminant. This is one company, but they threatened to shut down a couple of power plants in Dallas and lay off 500 workers. And that got Luminant an audience with the administrator, Jackson, right up there. And I remember one time when Bill Peterson, he's an old administrative law writer, said we were working on some rules, some procedural rules at EPA, and he said, why don't we think about this? We'll give them trial-type hearing, if that's what they want, or we'll give them 3 hours with the administrator. Right? That's your choice. Now, that's an interesting thought, because the administrator will be the ultimate decision maker. And these days, it happens, but it's not through any formal rules that Bill Peterson wrote, but it just happens as you can make it happen politically. We get intense congressional oversight, lengthy confirmation battles where we're trying to make sure that our guys are in and their guys never get there. Witness the Consumer Financial Protection Bureau, its statute, the Dodd-Frank Act when it was passed, and I think Stavros is going to talk about this more perhaps. Its statute said, insofar as it's doing new regulations under this statute's authority, you can't start until you have a director. So the deal was, Senator Shelby said, well, you're never going to have a director because I'm not going to let you have a director until you decide to change the agency to not be headed by a single person, but be a 5-member bipartisan agency. And until that happens, you're not going to get an executive director, which is to say you're not going to get to regulate. And that happened up to the point at which just early this year, President Obama, in a very controversial move, gave Condrey what do you call it? Recess appointment, that's it. A recess appointment, and it's query whether that's being challenged. So anyway, so we have rifle shot legislation and riders. I actually have another article in a Michigan journal of law and administrative law and policy on the rifle shot riders themselves. So I don't focus on it in this article at all, but it's an important phenomenon that you just cut off the funding for this rule. And you just keep doing it every year. And pretty soon, the rule it permanently doesn't happen. In any event, I wanted to talk about the implications of this, particularly since Professor Watts here, and I was very taken with her article about political considerations being, one, appropriate, and we ought to recognize that it happens. Well, that's for sure. But how does that play out in a in a context of blood sport rulemaking, where politics, where implementation is not just politics by other means, but implementation is politics as usual. and the rulemaking process doesn't look a whole lot like law anymore. Well, certainly it has implications for legitimacy. I mean, I say trees have been wasted about the whole notion of how do we make what agencies do sound legitimate to those who are affected by it, so they'll accept the decisions. And in this highly divided era, I don't think there's any amount of procedure you can add. I don't think there's any amount of explaining that can be done that will convince a lot of people in this country right now that anything an agency does is legitimate. Okay, and if we're in that situation, maybe we don't spend a whole lot of time trying. I don't know. We just say this is a political battle, and if we win, we get to regulate, and if you win, we don't. I don't know. That's just one thought here, is that we're spending an awful lot of time talking about legitimacy, presidential control, because it's majoritarian. Well, that's all well and good, and he's accountable, but as we're going to talk about later today, when the overtures come into the president, when, as I point out in the article, when you're doing the cross-state rule and the chief of staff of the White House is meeting with the lobbyists, and the chief of staff and one of the lobbyists from the American Petroleum Institute shows him in red and blue the impact of his rule on the states that his president won and lost in the White House, I don't know in terms of legitimacy, but it starts to, I don't know that we, how to make it work to make it more legitimate, and maybe we just accept it. Or we might try to do something to discourage that sort of tactics. That's our alternative. I talk about impacts for agency structure. One would have thought, well, independent agencies may be a way to stop this. Well, the example, the Interchange Rule, is the Fed, which I would say is arguably the most independent agency that we have, and it still was subject to the strategies, and it certainly affected the outcome of the decision. Talk about choice of policymaking vehicles. Perhaps if agencies like FTC has really gone back to, from the early 1960s, where it bloomed out and did some rulemaking, it's definitely back to just adjudicating now. It makes policy through adjudication. That, at least, the rules are still there. Ex parte conducts are forbidden. It's frowned upon. It's not supposed to happen. You're supposed to recuse yourself if it does happen, or at least put a note in the record that it did happen and explain why it doesn't affect your decision. So that's a possibility. The other route, of course, is much less formal. Policy statements, interpretative rules, and things like that you don't go through any procedures for. Talk about the quality of the agency leadership. I don't say any more than who needs it, right? If you're really good, why do you want to be in this position where you're going to spend 32 days of your first 64 days on the job, as Lisa Jackson did, getting beaten up on the Hill? What's the good of that? What does Elizabeth Warren? She decided to stay in it. She likes this stuff, so she's still in the game, but in a different focus, not in a much more political way. Transparency. A lot of this isn't terribly transparent, even as the OIRA has opened up to some fairly great extent, though there are certainly indications of backsliding from the John Graham days, but it does, of course, have implications for transparency. You're not going to know who's funding the attack ads that are being broadcast, or who's putting those ads on the metro rail cars as the bureaucrats go to and from their jobs. The quality of the agency decisions. Political considerations versus fidelity to the statute. That's something that we will be talking about a lot, I think, today. The Congress that enacted the statute meant something. Now, it may be a different Congress now, but they haven't overruled this statute. They haven't written a new statute. And until they do, the agency, I think, has some obligation to adhere to the policy decisions that were made in the statute. And I think Professor Short's going to talk about that much more than me, so I won't spend any more time on it. There are a couple of other implications, though, that I think the stability of regulatory regimes. I think this is important because if it really is just all politics, or an awful lot of it is about how one manipulates things to get your way, then if I'm a big company, and there are some of these out there, that spend hundreds of millions of dollars on scrubbers for their plants, and I see Luminant go to the administrator and get cut a break, that doesn't sound too fair to me. It sounds like this isn't a very stable regime. There's going to be some uncertainty here, a good deal of it, as to what the rules really are. And I think that's not in anybody's best interest, certainly not from the standpoint of efficiency, but not from the standpoint of just overall fairness either. I do talk about influence asymmetries, the fact that the beneficiary groups don't have nearly the resources that the regulatees have, and talk about, I rely a lot on my colleague and co-author Wendy Wagner for that. And then I probe some of the implications for administrative lawyers, a very interesting piece about the role that lawyers play in PR, when their companies engage in PR, and the idea of the lawyer for the company being the company conscience, and how that might play out when the PR is directed to something the lawyers are working on, that is a rule, an administrative rule. But I want to focus mostly on the implications for judicial review. Of course, judicial challenges to major rules, high-stakes rules, are routine. They've always been, since agencies have been engaged in high-stakes rulemaking. Judicial challenges have happened. And I think the test that's still out there for how far is too far is Sierra Club versus Coastal, understanding that it was made in the context of a Clean Air Act, which defines a record more narrowly, or maybe I should say more broadly, but differently than the Administrative Procedures Act. So there's always that question as to what the extent to which the teachings of Sierra Club versus Coastal are relevant to other agencies acting outside the context of the Clean Air Act. But the test basically is the content of this pressure that's brought on the agency from outside, in this case from the White House and from a congressperson. If that pressure is designed for the agency to consider and decide upon factors not made relevant by Congress in the applicable statute, so that's fidelity to the statute. And the second showing that you'd have to make on judicial review to attack a rule for this political influence idea is that the agency's determination must be affected by those extraneous considerations. That's, of course, the tough nut to crack, is to show somehow that the agency was affected by it. And I think Professor Watts has suggested to us that, and not the article for today, but in the previous article, that the court should expand the notion of valid reasons to include political considerations. Let's be honest, let's talk about the extent to which, let's at least get it out in the open, and I couldn't agree more. I think that this is a good idea. Don't make it sort of sub silentio. She limits that, I think, and she can correct me if I'm wrong, to political influence from the president or from members of Congress. That is, from other governmental entities. Could be, I'm sure, another agency. One serious problem with increased transparency is that the agency is never going to say, well, I was motivated by the fact that my president might not get reelected if I regulate too strongly. Nobody's going to say that. And that certainly wouldn't be a criteria specified in the statute, the political future of a particular president. But you can get around that, as she points out, because there is authority for the proposition that if you consider factors that are not explicitly identified in the statute, but still are consistent with the underlying policies of the statute, then those at least ought to be available to us. So she distinguishes between valid or permissible political considerations and invalid or impermissible political considerations, the first being those influences that would further the policy goals of the statute or public values in general or broadly. The second category being to seek raw political gain or partisan advantage, unconnected with the statutory scheme. Now, in the real world of high-stakes rulemaking, it's not likely that an agency is going to, if that's the choice, they're always going to frame the political considerations that they put forward as being of the former variety, right, of legitimate political considerations. A more serious drawback, I think, is that it leaves the matter entirely with the agency's discretion. The agency gets to decide what it puts on the record and what it doesn't. And that's what I would change. I offer several possible responses to Bloodsport rulemaking. I really just wanted to get this on the table. I'm not sure that there's a good response. I don't have the answer here by any means. I think one could think of structural shields by way of independence, certainly like independent funding. That's what Senator Shelby really hates about the CFPB, is that they don't have to go to Congress every year for the budget. For its first 5 years, they get it from the Fed, who charges the banking industry. That's how the Fed gets funded. That's what he really hates about this, and a lot of people in Congress obviously do, because it makes them certainly less accountable if accountability is accountable to the Appropriations Committee in Congress. But I want to talk about modifying judicial review and the notion of the record on review. I would like to take Professor Watts' her suggestion a step further. If we're going to make political considerations something we're going to talk about openly now, make it something for a legitimate debate, let's don't limit it to just what the agency decides to put on the record. Let's, when anyone suggests that political considerations are motivating the agency here, let them get that on the record and make the agency respond to it. Okay, so that an environmental group who didn't like down in Texas, and there's a couple, they're not real happy about the decision giving Luminant more credits. When they want to put on the record, we want to allege, because, and here's 2 or 3 newspaper reports based on, I'm sure, leaked, maybe not leaked documents, but just somebody talked who was there, that suggests that the decision was made of the rawest political sort. Those are illegitimate. Okay, one's got to say that the blue and red map thing, that sounds pretty much like partisan politics. If that's the case, let's get that on the record and let's make the agency explain it. Tell us why that didn't affect you. So I'm not arguing against reasoned decision making. I know that I just think that reasons have gotten a lot broader, or could get a lot broader if we went this route. Make the agency respond to the allegations, and then the courts can decide for themselves the extent to which they think the political considerations are just too strong. We could go back more to a Three Sisters Bridge kind of situation or legal regime, and we could still do it under Sierra Club versus Casa, but I would back off from Sierra. I would have the courts be a little bit more intrusive than Sierra Club versus Casa, at least in framing the record and defining the record, and perhaps in arbitrary and capricious review. Now, those of you who read my work, there may not be many out there, but know that I'm no big fan of substantive judicial review of rulemaking. I think that this arbitrary and capricious review of the substance of what agencies do is really too much of the courts. They call it, Judge Leventhal called it a partnership, but there was no question as to who the senior partner was. And I think that gets the courts too heavily involved. This, though, is more the sort of thing, if the bottom line test is fidelity to the agency statute, then it's more like what courts can and I think should do by way of judicial review. At that, I've gone too long, so I'm going to let Professor Watts tell us about her very interesting paper on moratoria. Let me get more water.
Thank you very much, Professor McGarity. Our second speaker this morning is as Tom McGarity said, an emerging star in administrative law, Professor Kathryn Watts, who is professor and associate dean for research at the University of Washington School of Law. And I note that early in her career, she was a law clerk for Justice John Paul Stevens of the U.S. Supreme Court, and I mention that also because Justice Stevens will be our graduation speaker this year at Duke Law School. So, and the kind of writing that Professor Watts has done has ranged across a number of administrative law issues, but in particular, relevant to today's topic was her earlier paper in the Yale Law Journal in 2009 titled Proposing a Place for Politics in Arbitrary and Capricious Review, which follows so nicely on the comment that Tom McGarity just made about his ambivalence about arbitrary and capricious review and horrors of the thought that there might be a place for politics in arbitrary and capricious review, that judges would be more brazenly political. But we'll let Kathryn Watts explain what she meant by that. And her topic today is regulatory moratoria, the fascinating episodes in which presidents or their chiefs of staff have declared there shall be no regulation for this such and such a period, perhaps when just coming into office or maybe even when about to leave office. And the juxtaposition of regulatory moratoria with midnight rulemaking, a flurry of regulations just at the last minute at the end of an administration, is a fascinating topic, again, at the intersection of politics and administrative law. So, Professor Watts.
Thanks so much. It's my pleasure to be here today. I'm eager to jump in and respond to some of the things that Professor McGarity said about arbitrary and capricious review, but I think I'll hold some of those comments off about my Yale project until maybe the Q&A and also the second panel today, where I know Professor Short will be touching on that topic, and jump right into my paper on regulatory moratoria, which I think fits really nicely with Professor McGarity's topic, because he was talking to you about, in his view, the new political toolbox. He was saying that these blood sports are part of the new political toolbox. And my paper is focused on one new tool, so looking kind of slicing narrowly at one new tool for political control of the administrative state that just hasn't been noticed. It's been largely ignored by scholars in the media and more generally. And so what I'm talking about is regulatory moratoria in the sense of executive or legislative commands that the regulatory machinery should stop. It should suspend itself. It should halt or freeze for a certain period of time. Might be a short period of time, a few months. Might be a much longer period of time, a couple years. To start by telling you the inspiration for this project and how I got interested in it, I live in Washington State since I teach at University of Washington. And in November of 2010, I was quite surprised when our Governor Gregoire, a Democrat, issued what she called a suspension of non-critical rulemaking. So she issued an executive order in which she told the agencies within the state that are under her control, suspend all rulemaking that is not critical. Well, what did that mean? What did non-critical mean? Were questions that I had once I learned about it. The problem was the media didn't pick up on this. It was only thanks to an excellent librarian we have who happened to notice it and put it up on her blog and immediately sent it to me that I learned about it. It just wasn't covered. It wasn't something that people really knew was happening in the state. And that piqued my interest because I wanted to know, is this going on elsewhere? Where did Governor Gregoire get this idea from? It was something that struck me as really unusual. I had heard glimmers of this happening before under Bush 1, but I didn't know a lot about the tools, and it's not something you see, as I said, in the literature. So my project started out with just digging, wanting to learn a little bit more about it and to see if Governor Gregoire was kind of a one-off, part of an isolated tool that's being used, or whether it fit into a picture of a broader phenomenon. And I was, I suppose, pleasantly surprised for purposes of having an article to write, to learn that it is part of a broad phenomenon that is being an increasing phenomenon, where we're seeing at the executive level and at the legislative level, both at the federal government and at the state government level, this increasing reliance on regulatory moratoria. So this was a project where I really had to dig, not just looking at through the federal lens, which is something that I think in the administrative law world we all do perhaps a bit too much. We ignore what's going on at the state level, and I think we do that to our peril, because I think in some scenarios we don't learn about phenomena that are going on. We don't see generalized trends unless we look at it through both the federal and the state lens. And this is one of those examples, because it's once you piece together examples of these being used at the federal level and at the state level that you see they are part of a broadly generalizable phenomenon. So let me talk a little bit about my findings in terms of describing the use of the tool. That's really the major aim of my project, is to describe the use of regulatory moratoria at the federal and the state level, to get it out there on the table so that scholars and others know about the use and when they're used and the different contexts in which they're used. And then the second part of my project, which I'll turn to next, has to do with starting the conversation about the propriety of regulatory moratoria. And that's really meant to be just a start of a conversation because, as I said, since we didn't really have a good sense of the fact that this tool exists, we don't have good studies. We don't know really the real impact. And so I'm hoping that an offshoot of this project is that more study will be given to this by political scientists, those in the policy field, economics, et cetera, down the road. So in terms of my finding, describing or backing up my claim that regulatory moratoria are part of a broader phenomenon. So if we start at the federal level, the story really goes back to Professor McGarity referenced Reagan's statement about how the problem is government. That's really where we can, I think, trace the origins of regulatory moratoria. It's back to Reagan and this notion of overregulation. In 1991, when he came into the presidency, he immediately issued an order, a memorandum, in which he told agency heads, executive agency heads, to freeze new rules for 60 days. And he did this, he said, there were really kind of two reasons embedded in the memorandum. One reason was it clearly meant to address this phenomenon of midnight rulemaking, to give Reagan a chance, in taking over the presidency, a chance to look back at those last-minute regs that had been pushed out under the Carter administration, and not to have them moving forward in the process, right? To be able to put a freeze on what had already been in place and was going forward. And so he did that by freezing new rules for 60 days and also postponing the effective dates of rules that had been finalized but had not yet become effective for 60 days as well. He also referenced in his order the economy. Economy wasn't so great in 1981, and he referenced the fact that the economy also was a reason perhaps for him putting a halt on the rulemaking process. So that's where we saw the first, what I'm calling soft regulatory moratoria. So in trying to get my arms around regulatory moratoria, I saw that there are very different contexts in which they're used. They're not all the same. It's not a one-size-all-fits solution. So some of them are imposed right at the beginning of a new administration, either a new governor coming into office or a new president coming into office, and they are designed to be short-term during this transitory period of political transition to respond to this midnight rulemaking type phenomenon. Others, which I call hard moratoria in my paper, are much longer term moratoria, not just keyed, not just limited to a period of political transition. They might span for 2 years, as we'll see in Washington State, or for 3 years, as we see in Arizona. So Reagan launched the phenomenon of soft executive-driven moratoria, not a hard moratoria. It was short term. After Reagan, every president to enter the White House taking over from a different political party has implemented a soft moratoria. So that clearly has become entrenched. So Bush 1 was the only president not to, because of course he wasn't taking over from a different political party. Instead, what he did is he also did a moratoria, but he gives us an example of a hard moratoria. In 1992, so it was actually in the last year of his presidency, it was during the midst of the election, an election year ploy, some claimed. He instituted what began as a 90-day moratorium, which he announced with great fanfare. So he announced it during his State of the Union address, again during a period of time when the economy was ailing, saying business needs a timeout. We need to put a hold on regulation to give a breather. We need to also have a breather so we can look back and weed out unnecessary regulations. So he announces this 90-day halt on rulemaking during the State of the Union, and then subsequently, through other very public announcements, he continues to extend it, so that in the end, it spans for a year. So he extends it during a Rose Garden ceremony in which he's flanked by the Vice President and others, and he later extends it in August when he does his acceptance speech at the Republican National Convention. So very publicized, very political, intertwined with his reelection, the fact that he announces the extension at the Republican National Convention. So he gives us an example at the federal level of a hard regulatory moratoria. In terms of non-executive regulatory moratoria at the federal level. We have some examples of the legislative branch looking at them, although we don't have any that have actually been enacted. The most significant example perhaps comes back in 1995, during the era of Contract for America, when we had the Republican Revolution in terms of the Republicans coming in and sweeping in the legislative branch. The House passed a bill, H.R. 450, that would have imposed a regulatory moratoria. It did not pass the Senate, but it got significant discussion and attention in the House. After that, it was quieter. There were, few bleeps where it's discussed at the legislative branch, but didn't really surge again until recently, when again our economy is ailing, and we saw an uptick. So in the last year, the last session of Congress, we saw more than, or at least 15 different bills that were proposed by the legislative branch seeking to impose regulatory moratoria. Again, none successful, but it shows that clearly the tool is in the mindset of the legislative branch, that legislators are thinking about this as a tool for political control. These proposed acts have names like the STRIP Act, which stands for the Stop the Regulation Invasion Please Now Act, the Regulatory Timeout Act, the Job Preservation Act. So these bills differ in their substance, even though their end goal is the same in terms of freezing regulation. But they have differences in terms of what they exempt from the coverage, for example, and differences in terms of the length. Some set a time frame for the length. Others cue the length of the moratoria to things like employment. So once employment falls below X level, then the regulatory moratoria will be lifted. In advocating for these moratoria, we've had politicians such as Susan Collins of Maine write an op-ed in the Wall Street Journal, appear on TV shows, and you see them analogizing to things like our economy is the athlete, right? And athletes need timeouts. And so there's very much this notion that business needs a breather in this country today. It is suffering, it's smothering, and it needs time to catch its breath. And so you see that coming out, that kind of rhetoric coming out very loudly and clearly in terms of the political speeches supporting these bills. Bills, again, that haven't gone anywhere, but that show that this tool is in the mindset of the politicians. So that's the federal level. At the state level, just to kind of summarize my findings quickly, we had some in the 90s, so at the same period at which Bush was experimenting with his, and when H.R. 450 was passed by the House, we had a couple states, Rhode Island and New York being the most prominent examples in the mid-1990s. Then we had a quieter period, and then again it took off in the last few years at the state level when the economy again took a turn for the worse. In the last 3 years alone, we've had at least 9 different states that have imposed some kind of regulatory moratoria. If we go back to 2003, that number goes up to 10 because we can put California into the mix. So we have California, Arizona, Washington, Nevada, New Mexico, New Jersey, Tennessee, North Carolina, Florida, and Maine that have all experimented with either an executive-driven or a legislative-driven regulatory moratoria. Nearly all of these have been soft moratoria, except a few, like Washington State, where it will last for more than 2 years, and Arizona, where it will last for approximately 3 years, and Nevada, where it will last for 1 year. And also, nearly all of them have been ordered by Republicans, with a few exceptions, Washington State being a very prominent exception, since Gregoire is a Democrat. That differs from the federal level, where, as I said, soft moratoria have been used by Republicans and Democrats alike. So that's the descriptive portion of my project, establishing that this tool has emerged. It's here. And the second part, as I said, I turned to try to think about the policy and legal implications. Is this a good thing that we're seeing our politicians turn to use regulatory moratoria to try to impose a halt on the regulatory process? And so in this part of the paper, I try to weigh some of the costs and the benefits that I see of regulatory moratoria, again, just trying to start the conversation. The main benefits that are touted in favor of them generally tend to be achieving cost savings, achieving a predictable regulatory environment, a stable regulatory environment. And the third is, although you don't see it expressed quite this way, I think clearly seems to be listening to voters' concerns, democratic responsiveness. Voters are concerned with overregulation, so we, the politicians, are going to listen. Problems I see with these big benefits, or purported benefits, is the cost savings just aren't proven. Again, because people haven't paid attention to this tool, we don't have much by way of studies that show whether they're actually having an impact, actually achieving cost savings for businesses, for example. Plus, there's the problem of weighing the benefits to a certain slice, like business, against the harm of not regulating to everybody else in terms of harm to the environment, harm to public safety, harm to public protection. So I don't see that as being tremendously weighty at this point, barring future study that shows that they are actually yielding cost savings. In terms of the claim that they'll create a stable and predictable regulatory environment, I like Jonathan Adler did a blog post responding to Susan Collins' Wall Street Journal's piece, and he said, it's like kicking the can down the road, right? In the sense that if you put a regulatory moratorium in place, you're just postponing for maybe a year, kicking the can down the road, the point at which regulation will then occur. So you're not really creating much by way of regulatory stability or consistency. The listening to voters' concerns, I think that is a valid one, that clearly politicians are listening to voters' concerns. Gallup polls show quite strongly that overregulation is a real concern at the top of businesses' minds and general Americans' minds. So there I do think we do see that occurring. The cost, though, so we've got maybe minimal benefit in terms of political responsiveness. The cost I see is quite weighty. And I'll just kind of outline a couple of the costs that I see briefly, and then maybe in Q&A, if there's questions, we can explore them in more detail. One of them is legal challenges. There's a lot of interesting separation of powers questions, I think, swirling around the background of regulatory moratoria. A recent case decided in Florida, which granted rest on Florida's own unique separation of powers analysis, but it found a moratoria in that state to be unconstitutional for separation of powers concerns. I think that case highlights what lurks in the background of these regulatory moratoria in terms of potential separation of powers issues that could be raised when we're talking about hard regulatory moratoria. Soft regulatory moratoria, I think, from a separation of powers perspective, are a bit easier. One, we have acquiescence to the extent that they've become established. So to the extent you believe in sort of adverse possession in the constitutional sense, we have some of that going on here. Another is that the president does have the power, the appointment power, and his argument can simply be, in order to make my appointment power effective, I have to be able to institute a short-term freeze for a short period of time to get my new appointees into office. And so I'm just trying to effectuate that appointment power. I'm not trying to decide the substance long-term by locking in the status quo long-term. It's short-term. So you could see it more as overseeing rather than deciding. To use Peter Strauss's term in separation of powers, he thinks about the difference between overseeing, okay in his mind, deciding not okay. So a couple reasons why I think soft moratoria can survive those legal challenges more easily than hard moratoria. Undermining transparency, that's another concern surrounding these. Creating regulatory confusion around the exceptions, because of course there's exceptions built into these, which leads to questions about what the exceptions mean. And then there's real concern in my mind that these moratoria are just simply evincing a really blunt anti-regulatory bias, which just views all regulation as bad, rather than thinking about the fact that regulation is not inherently good or inherently bad. It depends on how it's written. So those are similar analyses for soft and hard, except that soft can more easily overcome the legal challenges. Another thing that I think soft has going for them that I'll mention and then I'll stop is that soft have an additional benefit that I didn't mention with respect to hard, and that is I think they help further political accountability. So the fact that soft moratoria are being used at a change in political administration suggests that they're being used to further notions of democratic responsiveness, which when we justify our regulatory state by situating it within the political control model is something that we, I think, should want to condone and enable. This notion that midnight regulations are anti-democratic, they're illegitimate from a political accountability standpoint. In other words, when the regulation occurs post-election, the voters have lost an important tool for trying to manage and trying to exert control over those regulations. So soft moratoria help deal with that problem. And for that reason, I think they have a significant value added to them that hard moratoria don't. So in the end of my paper, I cautiously suggest that soft moratoria are a tool we should think more carefully about and perhaps could be a valid tool, whereas hard moratoria I see little value to and I warn against. So I look forward to discussion.
Thank you both very much for very interesting presentations. We have some time for questions and answers. I was struck at the athletics metaphors in both presentations. Blood sport. Whose blood is on the floor in that sport, maybe the blood of the regulators or the victims of who've not gotten the protection from regulation that they needed. But then, at least in Kathryn Watt's presentation, or maybe it was Susan Collins' portrayal, it was the economy was the athlete needing the timeout. So one question I think we might ask is, how much do these metaphors or narratives of who the contestants are and analogies specifically to sports that we all play growing up, how much do those influence, apart from careful technical cost-benefit analysis or cold political calculation, is that just a passing reference, or is that actually driving some of the behavior of the players in these dramas, to mix another metaphor?
I have some thoughts about that, because I have wondered a lot about whether the fact that we have politicians continually making statements like that, right, that businesses need a timeout, that the economy needs a timeout, that overregulation is our problem, when the voters are repeatedly hearing that over and over again, you start to wonder, it's like a chicken and an egg kind of a problem. You're not sure if the politicians are actually creating the voters' views by using this rhetoric, or whether the voters have these views and hence the politicians are using the rhetoric to respond to the voters' views. So if they're using the rhetoric in a responsive manner, such that we could say that democratic responsiveness is being furthered, then I guess perhaps it's not that problematic if we value democratic responsiveness. But I think it's more of the fact that the politicians, by using the rhetoric, are often creating the climate among the general public, and that I find more problematic.
Yeah, I guess I would agree with that. I think that's a very keen insight. It comes from the politicians. It also comes from these the talk show hosts and the bloggers and that sort of thing. And I guess if the question is, are the sports metaphors really, are people getting captured in that? Yes, I think that people much more so than when I was a law student and just getting into to the study of law. Politics are competitive now in a very serious way. And if anything, maybe the sports metaphor is better than the alternative, which you certainly hear in the rhetoric, which is war metaphors, right? The answer here isn't, as Tom DeLay would say, I want to kill this agency. Mm-hmm. We're at war here. Often you hear that as reports of the various meetings. We're at war here, and so it's not even blood sport at that point. It's just war. So I almost prefer the sports metaphors, I suppose, to the war. So where the outcome is just victory instead of drowning the baby in the bathtub.
Let me ask you both one other question, which occurred to me during your talks, which is, I sort of had a sneaking feeling in both talks that an unexpected antidote to the problems that you are describing is the rise of presidential administration and the application of cost-benefit analysis or technocratic analysis of regulation. And here's what I mean by that. That is, for example, Tom, in your talk, you mentioned towards the end that although you haven't been a fan of arbitrary and capricious rulemaking, or at least as a substantive review by judges of agency decision-making in the past, there might be something to it in well done as a response to excessive political lobbying and excessive political intrusion into the rulemaking process itself, too many hours with the agency administrator by the special interest group, for example. And similarly, I thought, or in a different way, but relatedly, in Kathryn's talk, the interesting, I think, well-taken point that a freeze on regulation or a timeout might have some cost savings, but also has other costs imposed or benefits foregone. So if the rule itself, if the rule as it was proceeding through the normal rulemaking process before the moratorium was issued had passed a benefit cost test in the regulatory impact assessment and a Weiner review, then presumably it was worth promulgating this rule for society, and abandoning the rule would fail a benefit cost test. And then the more nuanced question is whether the freeze, the temporary freeze, would be, at the margin desirable or undesirable, given the kinds of other factors you mentioned about stability or just postponing the compliance. So is there some sense in which if presidents of both parties have agreed that they want to have an oversight mechanism using technical methods of analysis like benefit cost analysis, that's a more rigorous and more even-handed and more, if it's done well, and more transparent process than the kind of backdoor politics of blood sport or the overtly political freeze? Won't you agree that that's the antidote?
Yeah, I knew you were going to go there. I guess maybe just seeing blood sport strategies playing out make me a little more friendly toward arbitrary and capricious review, although I would probably still tie it to statutory interpretation. I think that the Supreme Court's gotten it exactly backwards, and that Chevron, that courts do know how to interpret statutes, and why they would yield to agencies who clearly are motivated by a lot of things other than what the law means is an oddity in my view. And so I would tie this again to fidelity to the statute. That's the key to me. And to the extent that the agency is straying far afield, we can call it arbitrary and capricious review, or we can just call it ultra vires. That I would have the courts be more active here. So you're right. I think that represents a bit of a change in my thinking on this. With respect to cost-benefit analysis and the rational model as applied through the president and OIRA, I don't think I'm willing to recant there. Have been very skeptical of cost-benefit analysis. I wrote about it. I can, from all indications, I'd love to talk to the people who are more involved in it, and maybe someday when Cass is out of there and is talking to me again, I'll discuss it with him. But from every indication, for example, the ozone decision that was imposed upon Administrator Jackson was made in the White House, and the OIRA's cost-benefit analysis, as far as I know, had nothing to do with it other than the letter that he wrote to Jackson to, after the fact, explain it. Made a lot of mention of cost, which, of course, we know from the American Trucking Foundation versus Whitman Supreme Court case is supposed to be an irrelevant consideration in setting national ambient air quality standards. So if politics is determining the outcome of the cost-benefit analyses, which I think it can do. You were saying that presumably if the cost-benefit analysis shows that the benefits outweighed the cost, well, depending on how you do that it would be a bad thing to repeal it. Depending on how you do the cost-benefit analysis, I view them as eminently manipulable. You can have both the policy and its obverse be cost beneficial. It's the Skatofsky paradox or whatever, but it depends on how one frames the inquiry a lot in doing the cost benefit analysis. So I wouldn't recant on cost benefit analysis, but I might be a little bit on the arbitrary and capricious.
I think I agree with some of what you said in the latter part of your answer, and I guess I would just add that cost-benefit analysis is not as black and white, right? This, as you say, manipulable. Different administrations might weigh the costs and benefits differently. If we look back to Rehnquist's concurring/dissenting opinion in State Farm, where he acknowledges this, that different administrations might weigh costs and benefits differently in light of different presidential or administrative priorities. And I think if we acknowledge that, then it's difficult to say that simply because under a prior administration costs and benefits were weighed X way, that is the only way to weigh them when we've got competing priorities at play.
But that invites the moratoria, right? I mean, that's Rehnquist's opinion in State Farm is saying the new president should get to change the regulatory policies because elections matter and the priorities have changed.
Exactly, which is why I'm comfortable with soft moratoria because they are key to presidential changes, whereas hard or not.
Okay, let's, Jen.
I actually had two sort of specific questions.
for Professor Watts on the idea of selective hard moratoria. You sort of hinted that these moratoria are not, not always sort of just across the board. They have exceptions. I'm wondering if you could describe a little more the type of exceptions, and whether you think that it's more constitutionally problematic if, a president came in and said no moratoria from a particular agency, or if that's actually more democratically responsive. As we see sort of Republican candidates get up and promise to get rid of particular agencies, does that sort of raise the benefits of a hard moratorium in that sort of situation?
Mm-hmm. Mm-hmm. So in my project, I tried to look at generalized moratoria in the sense that they were not subject specific, because you do sometimes have legislative proposals that say EPA can't promulgate any regulations dealing with ozone, for example, right? And so those I cabin off in my paper as being different. But within the rubric of generalized that are more substantively generalized, the exceptions run the gamut, depending on what moratoria we're talking about. Generally, they include some kind of a public health emergency kind of an exception. That's pretty common, so that if the public health necessitates it, then the reg can move forward. Although there's a lot of squishiness and ambiguity. In Washington State, Department of Ecology, which deals with our environmental law issues, has had real difficulty trying to figure out which can move forward and which cannot. At the federal legislative level in the last year, some of them included exemptions for things like civil rights. Some of them include exemptions that says if the regulation is going to create jobs or help the economy, then it may move forward. But if it's going to hurt the economy or not create jobs, then it may not move forward. So you see all different permutations in terms of how the exemptions are written, and that's one of the costs that I see of them, is that you just have a lot of questions that arise and a lot of time that has to be spent trying to figure out what these exceptions mean.
Can I just chime in one thing, because I did a little work on moratoria back in '95, and that one they had a real problem, because somebody said, every pesticide tolerance that EPA issues is a rule. Okay, they do it. It's a rulemaking process. Pesticide tolerance allows you to use your pesticide on. You can't get it really registered if you don't get tolerances for the amount of pesticide on your food. It's verboten without a tolerance. So EPA, if you go look in the Federal Register, I'd say a good proportion of the rules it issues on any given month are pesticide tolerances. Well, those were all going to be stopped, and the industry didn't want that. There are lots of things that agencies do that empower when you have gateway statutes, I call them, that have the writers of these moratoria searching around for ways to write exceptions narrowly tailored to things that will allow the favored industry to do what it wants to do while stopping the agency from doing what they don't want it to do.
Which those exemptions help highlight the generally anti-regulatory bias that's embedded within these. Yeah.
You had a quick other question?
I had another question for Professor McGarity.
Great.
So it seemed like when you were talking, I was asking myself whether your concern with the politicization was a procedural concern or a substantive concern or both, because you sort of hint that like the loom-in exception is an example of sort of substantive unfairness in the rulemaking. And if you like look at maybe a regulatory moratorium, that seems like it's, fair across the board, but it still is potentially caused by the politicization in the process. And would you consider that sort of the driving problem or both?
Well, that's an interesting question. I don't think it's entirely all procedural, unless one defines procedural very broadly as the problem here. Though, and there is a substantive component to it. I could just, lay my cards on the table. As I said at the outset, I believe that when Congress writes a statute, it's usually because some industry is really screwed up, and Congress is trying to fix a problem. Okay, and people come to the problem and say, look, people are hurting, fix the problem. So they fix the problem, they think they fixed the problem, and the implementation process is about the actual fixing of the problem, which in the case of the Consumer Financial Protection Board hasn't started yet, may never start. Okay, so there is that, and to the extent then that blood sport strategies, and they're not just exclusively used by business, by the business interests, but they overwhelmingly are used by business interests because they have the money to spend, $24 million on an ad campaign against a rule. Okay, NRDC though has done some fairly fairly sophisticated ad campaigns in its time. Natural Resources Defense Council and the Sierra Club's got millions that Carl Pope got people to contribute to do ads on their anti-coal campaign. So if you looked at the coal, or the fights over the power plants, which, as I said, I took out of the piece except for little pieces here, you find that some fairly successive ad campaigns by the environmental groups, too. I hope I left that in. If I didn't, I'll try to remember to do it.
Katie?
This is more a question for Professor Watts. I was wondering if you found any evidence of what's going on in the agencies when after the moratoria are issued. Presumably the staff people don't go home. Do you suspect, or did you see any evidence that that's actually being used to create space for the type of blood sport politicking that's going on? Is there an uptick in the number of meetings between regulated parties and rulemakers? If you didn't see that, do you have any suspicions one way or the other?
Yeah, so it's a great question, and I wish we had the answer to it, but we don't know a lot about what's going on behind the scenes in terms of how it's impacting them, and that's one of the big concerns is the lack of transparency surrounding how these moratoria are implemented. So I talk about that transparency problem in the paper some. Washington State, though, is interesting because their agencies have, for example, Ecology, created pretty detailed websites in which they've laid out the regs that were in the process of moving forward when the executive order came out, and then they give you updates as they decide, is this something that falls within exemption? If so, what exemption? A little bit about what's their reasoning? Can it move forward? Or is it halted? Or are we still studying it? So in Washington State, we have a little bit of a glimmer into it, but in most places, none. When that was a big criticism of Bush 1's moratoria back in 1992, is that he had all these claims of 15 to 20 billion a year of cost savings, but people didn't know what regs and how was the impact occurring, and there were a lot of FOIA requests to try to figure it out, and the FOIA requests didn't lead to much. So that's something that I'm hoping, again, now that we have some kind of natural experiments in states like Arizona and Washington State, that it would be something not for the legal academics, but maybe the policy types and some empiricists to be able to take a look at the data and try and figure out what impact, if any, these are actually having. Because if they're not actually having much of an impact because we're cramming everything into the exceptions, then it helps undermine the basis for them.
My question is that, perhaps it's not as much of a question, but I work in environmental policy, so I'm seeing it through that lens. But the statutory requirement that the agency continue to, for example, revisit air quality standards every 5 years, that doesn't go away under a moratorium. So it seems like it would just get backed up, and when the moratorium ends, you would have a lot of new rulemaking, which, as we've seen recently with fossil fuel-fired energy generation rulemaking, the regulated entities don't respond gracefully to that. And it seems it would just perpetuate the problem that it's attempting to resolve.
So most moratoria, in terms of the exceptions, include an exception for regs that are mandated by statute. So if there's a statutory command that the agency make regs every 5 years covering X, then that would generally be exempted by the terms. So that would help with that type of a concern. But nonetheless, your general sense that, yeah, we're going to end up with this backlog, it's the kicking the can down the road phenomenon, right? That's certainly true.
But is there a flavor of Brooks's point that it actually could be worse for business and industry to have the congested cluster of regulations issued at the end of the moratorium rather than have had them spaced out more gradually, even if they could be stopped, that is, if they're not subject to a statutory deadline?
Yeah, I mean, certainly from a regulatory planning perspective, you would think, from industry's perspective, you'd rather not have a huge hit all at once, I think.
I think maybe we should disaggregate things just a little bit here, because I think your point has an answer. For a soft moratorium, that's going to be, if the industry likes what the new administration, they're going to like that. If they don't like the new administration, they're going to be against the moratorium. It's not going to slow down the agency, right? But at the end of the day, you run into the moratorium's lifted and the agency still has these statutory requirements. The industry may not care that much because they know the agency's still not going to do it until they get around, until they can actually do it. And they'll use the moratorium as an excuse. And yeah, you'll pass a statutory deadline, and some environmental group will sue, and 5-10 years after that, you may get a standard. So they're not so worried about that. As I think the hard moratorium imposed on a president by a Congress, maybe dominated by the other party, now that has some serious implications for what happens at the end of the day, because the agency wants to write that rule, and it can't, and now it's stuck by the statute. Then I think maybe you get that.
Yeah.
Maybe the people that actually get a timeout isn't the economy, but it's Republicans and Democrats, but given that that's unlikely, is this not that maybe the point where we're more divided than ever before, but we're just as divided as we've been in the past? It's just now the focus has come back to the role of government, and the ultimate solution is just to say, we can't actually solve it and put you apart and time out. So let's let you just fight it out, and let's see where regulations go from there. We can have more, we can have less. Can we resolve this through the political process like we've done with so many things before this? And then perhaps, just as a side of that question, Professor Watts, is a soft moratorium something that can be used to perhaps temper the tone of the debate at different times to maybe bring something of a timeout to this process?
You want to start?
Go ahead.
Whether a soft moratorium could temper the debates in terms of this nasty political climate, I'm not sure. It's a good question. The fact that they've been used by Democrats and Republicans alike, right, gives me some hope, right, that it's not just one-sided. Whereas the hard moratoria seem to be much more skewed to the Republican side, which makes sense given that they have a much more embedded anti-regulatory bias, which a soft moratoria does not necessarily have. But I don't know how much even soft moratoria help kind of quash that political furor, because of course they are based on political responsiveness. They're based on the notion that we have differences between the parties, and that when you have a change in administration, a change in political parties, you can have a change in views. So it's just highlighting that fact and elevating it, which I don't know if it helps solve it. But your instinct that this divide that we're in really is animating all of these debates, I think, is absolutely right. And these comments, as I'm sitting here thinking about it, make me kind of loop back to the non-delegation doctrine in many ways and think about our fiction, of course, that we pretend that what's going on with regulation is not legislation, but all of this just highlights how it is so very much legislation that's going on when we're talking about regulation. It is lawmaking, and if we all accept that and abandon the fiction, then maybe the fact that it's politics as usual that's driving it is not so shocking. It's still concerning because we had all these constraints that helped enable us to do away with the non-delegation doctrine. So maybe it brings us back to that debate full circle.
Well, that's a very interesting observation that we could bring you back to there, because that would suggest then that all of what agencies do is unconstitutional. An awful lot of what they do is unconstitutional, and therefore, thereby the Republicans win, right? I mean, really, that's what you're saying. If you don't like regulation, then you just declare it unconstitutional.
But that point, or even the hard moratoria, would also block Homeland Security regulations. So we.
Well, that's a good point. That it would cut in all sorts of directions, and I don't know what you do about tolerances when you do that.
Yeah, I have a question.
Yes, Sarah.
I was just curious, Professor Watts, you draw a distinction mostly between hard and soft in terms of the time length. But I was wondering whether you saw the moratoria that are imposed by legislatures as being more legitimate than those imposed by the presidents, or perhaps if a moratorium were focused more on executive agencies and to let independent agencies continue to do their thing, if that would be more legitimate in terms of the separation of powers concerns and the other concerns.
Yeah, so the moratoria generally are written carefully to cover only agencies that, whether it's the governor or the president, can reach. So independent agencies, for example, under the terms of federal executive orders, are encouraged, right, to think about following the principles, but not required. So generally they're written in a way to deal with the executive independent divide and not trample too much on that. And the first part of your question, I just lost me. What was the first part?
Whether the moratorium imposed by Congress.
Oh, by Congress is more legitimate. So I think if it's imposed by the legislature, then we don't have the separation of powers problems very clearly, because it's not the executive that's dictating how agencies act. So we don't get into this whole, directive authority, unitarian executive separation of powers issue. So that falls off the table. Nonetheless, I think all the other concerns in terms of creating uncertainty, the cost-benefit analysis, all of that still sticks, but the tricky separation of powers questions go away when it's a legislative decree rather than executive.
And now we must go away. So the time's come for our break. I want to thank our two speakers, Kathryn Watts and Tom McGarity, very much. And I think we have a 10-minute recess, and then we will, during which some appointments will be made, and then we will return for the next session. Thank you very much.
Produced by Duke University. Online at duke.edu.